maintaining eye contact. He's always maintaining a certain composure about him. You can see he's a little nervous about what's coming out of his mouth right here, and you can see that he keeps looking down, possibly to a piece of paper, or possibly trying to find the words that he's supposed to say in his head. But either way, he's scripted.
The fear of the event needs to be made more troublesome than the event itself. By doing what the president is doing, he is making the fear of the event, which supposedly more terrible than the actual event when it hits, but I'm not sure that's the case.
No, it's going to be a bombshell.
I think the fear before the event and when it hits for these deep state coup plotters who are being exposed and melting, I think it's going to be bad at both ends. But by doing what he did, by turning this over to Barr and saying, you go right ahead and declassify all this stuff, Barr is working with several prosecutors, one of which is this John Durham, who, from all my contacts, say, real deal, tough, honest, doesn't play a political game. This guy will take out anybody and everybody that's not playing fair, not playing right, not playing by the book, and anything associated with criminal activity. Well, we welcome the new sheriff in town.
Thank you, Mr. Chairman, and I appreciate especially the last, and I would extend my prayers and thoughts to Ms. Dean as well. I'm just a little under a year. In fact, Monday this week will be 1 year from losing my mother, so it is, for all of us, we go through that, and it's an expression of love. However, I will come to this hearing today and say that we're continuing. I appreciate the chairman's understanding. I appreciate the chairman outlining a great deal of the basic conclusion that was an affirmative conclusion from the Mueller investigation. That was the foreign interference from the Russian part of this. What is amazing, though, and I agree with the chairman's assessment of being attacked, and it's something we've known. The Russians were always a part. For some of us, we've been talking about the Russians for a long time in that. But it's about priorities. And here's my question about priorities and coming to this hearing. And the question of priorities is if we were attacked, as the chairman just said, then the priority should be to go to the battlefield on the attack where we were attacked on, and not run by the sideshow to hear from the commentators. We should actually go to the one that Mr. Mueller actually said was, we have a problem here. We're showing you we've actually induced indictments here. How can we firm up our elections? How can we do away with foreign interference? How can we do that? It's about priorities. And I think what has happened here is the chairman is showing the priorities. The priorities were from November 2016, it appears that we have an issue with who got elected president. And we thought the Mueller investigation would solve this for us, and it really did not, even after a lot of discussion. We're going to hear a lot about that today and the discussion that we have. But it goes back to priorities, and priorities of bringing what we focus on and how we focus on it. And if you look at the witnesses today and you discuss what was actually just went on for a while, we're not bringing Russia front and center. We're not bringing the threats to our election front and center, although I appreciate the chairman reading the letters that I sent him and understanding what we could actually be working on. And I'm wanting to move forward there. But however, here we come with some folks that are great folks. You're wonderful on TV. I could catch your testimony on TV. In fact, by the way, I could this morning. I'm a Republican. I believe that you use everything that you've got to as much business as you want and generate as much as you want to work for yourself. But I don't believe it's the problem of this committee to have to come and hear from those who are not a part of the Mueller investigation, who are not a part of this, pontificating on things that you can do on TV like all of us get a chance to do occasionally, but not here on the hearing. But then we get, and I'm sort of reminded of the Russia priority issue, because just a few years ago it was brought up, and one of our candidates talked about Russia being a threat, and the former president, Mr. Obama, said, you know, that the 80s are asking for their foreign policy back. Well, guess what? This committee is now hearing from the 70s, and they want their star witness back. In fact, it's very difficult for one of the witnesses here today, for many of us who can actually trace the distrust in government back to the witness here today. The 70 star of obstruction. In fact, I'll take it a little bit further. For those of us who've been looking into this for a while and wondering how we got started here, and for those of us who've heard me discuss the fact, and many on our committee and on our side discuss the fact of the corrupt cabal, what we see of Strzok, Page, McCabe, Comey, and others, how we actually got started here, I believe that they have the Godfather here today. Mr. Dean. In fact, probably had a picture of how do we actually use the governmental resources to interfere in other people's campaigns. Mr. Dean is the godfather. They may even had a picture of you, knowing how you do it. And that is here today, again, to talk about a president that obviously you don't like, an interview in ways that you had pled guilty to. I appreciate your right to be here. And I appreciate your right to share it anywhere else. But don't appreciate the fact that here we are again with priorities in this committee turned upside down. It is interesting to me, and I applaud the chairman for finally getting accommodation processes from the Department of Justice that he could have had a long time ago. I'm glad we got it there. Now maybe we can move forward. Maybe we can begin to put this committee in order. But I would just go back and just say that I would ask my chairman on who we do agree on some things. Hopefully tomorrow we're actually going to have a bill we agree on, the 9/11 bill. But while we continue this part, asking opinions from commentators, promoting their agendas, my question is this. At the end of the day, for these not here, they're here commenting on a report. I go back to what the chairman asked, and he said, well, we may get there. And I said, it was, we hope, I think was the exact words just a moment ago, to have Robert Mueller. Hope. This committee is obsessed with a document in which they could talk to the author, and we seem to not want to go there. We're hot and heavy to get everybody else here, but we don't want to go there. Because at the end of the day, the Mueller document, even despite his standing up in statements, stated there was no collusion, which is where it started. Where it started, there was that contact, and there was no charged obstruction. But here we are again today. Here we are looking at it as we go forward. Why? Because there is an obsession. There's another election around the corner. And that other election is simply being played out here. How can we damage the president? Because we don't like the cards that we got to run for re-election
Thank you,
on.
Mr. Collins. I will now introduce today's witnesses. John Dean was the White House counsel under President Richard Nixon. He is most well known for his role as a principal witness during the Senate Watergate hearings, where his testimony was later fully corroborated as to its truthfulness by the revelations in President Nixon's White House tapes. Prior to his time in the White House, Mr. Dean served as the Republican chief counsel of this committee, as well as the associate director of the National Commission on Reform of Federal Criminal Laws. He has a BA from the College of Worcester.
Chairman Nadler, excuse me, Ranking Member Collins. The last time I appeared before your committee was July 11, 1974.
Jesus
during the
Christ.
impeachment inquiry of Richard Nixon. Clearly, I'm not here today as a fact witness. I accepted the invitation to come here today
Push
because
my
I
new
hope I can
book.
give a little historical perspective on the Mueller report. In many ways, the Mueller report is to President Trump what the so-called Watergate Roadmap, officially titled the Grand Jury Report and Recommendation Concerning Transmission of Evidence to the House of Representatives, was to President Richard Nixon. Stated a little differently, Special Counsel Mueller has provided this committee with a roadmap. Drawing from my testimony, I'd like to offer a few, actually just one I'm going to focus on, parallels I find with the Mueller report. I've laid out in my prepared statement 6 examples. Those examples are illustrative rather than exhaustive. But let me turn to the 6th, and anybody who has any question about the prior 5, I'm happy to address. The 6th is the Mueller report's effort regarding the influence of witnesses with pardons. As the citation shows, it's spread out throughout the report. Mr. Mueller addresses the question of whether President Trump dangled pardons or offered favorable treatment to Michael Cohen, Paul Manafort, Michael Cohen, and
Well, you're a fucking moron. How many times are you going to say Michael Cohen? The guy who's in prison right now for lying to Congress? Jesus Christ, where do they find these fucking morons?
Roger Stone, whose name is actually redacted, but based on educated conjecture, I think that's pretty clear who it is. And the question is whether in return for their pardons, they agreed to, or the suggestion of a pardon, he was seeking them to keep their silence, and how they coordinated with investigators. But also the Mueller report offers a very powerful legal analysis that, notwithstanding the fact that the pardon power is one of the most unrestricted presidential powers, it cannot be used for improper purposes. And I give the cite of that argument. What's interesting is Richard Nixon, who used the pardon in a similar way, recognized that it was improper. For example, in December of 1972...
If we want a fucking history
Chuck
lesson,
Colson
we'll
went
read
in
a
to see
book,
the
you fucking moron.
And when Hunt was given the word, the so-called... In one of my last conversations with Richard Nixon, he told Don McGahn,
opportunity to testify and answer your questions. Let me cut right to the chase because I am a law professor, and so I'll start with some basic legal context. The federal principles of prosecution direct prosecutors to indict a case only if they believe they can obtain and sustain a conviction. That means obtain a conviction at trial, sustain it on appeal. The Mueller report sets out the three elements prosecutors have to be able to prove for each charge of obstruction of justice they would potentially bring: an obstructive act, a nexus between that act and an official proceeding, and a corrupt intent. So those are the three elements prosecutors would have to be able to prove beyond a reasonable doubt at trial.
And they didn't. And they couldn't. So what is this dog and pony show about? Dirty in Trump's name.
Gentleman from Florida, Mr. Stewart.
Thank you, Mr. Chairman. It's fascinating to me that the majority brings in Michael Cohen, a convicted liar who lied to Congress as a witness, and now the majority brings in Mr. Dean, who's convicted of obstructing justice, and is paid by cable networks and others to opine against the president. So instead of legitimizing Mr. Dean's presence here today, I'll ask my questions to Mr. Malcolm. Mr. Malcolm, isn't it true that the president could have exerted executive privilege and prevented Mr. McGahn and others from cooperating with the special counsel?
Yes.
And in fact, not only did he encourage Mr. McGahn to cooperate, he allowed 20 White House officials to testify, including 8 people from the White House counsel's office.
Correct.
Isn't it true that the president has full constitutional authority without reason to fire the FBI director at any time?
Yes.
So how would it be obstruction to fire an FBI director?
I don't think it was. I would also point out that the report also indicates that others within the intelligence community, and Attorney General Sessions himself, had suggested that the president ought to do that before the president decided to do it.
Isn't it also true that if the special counsel had decided on the question of obstruction, he could have stated that there was evidence the president committed obstruction and recommended that he be charged with obstruction and not kick the decision to the AG?
He could have done that, yes.
And he could have recommended any form of charges that he wanted to recommend, including if he had found anything on Russian collusion or conspiracy or any of the method.
While recognizing that it would not result in an indictment, he could have said the evidence was there to convict the president if he could be charged, yes.
Which he did not.
He did
And
not.
kicked the decision to the Attorney General of the United States, who said, and I quote, "There's not sufficient evidence to establish that the president committed an obstruction of justice offense."
That's correct.
Could you walk me through, as an attorney who's spent a number of years practicing in the courtroom and having numerous clients, could you walk me through the chilling effects this is all having on future presidents having honest and open and frank conversations with their White House general counsel?
Presidents engage in, one, they solicit advice. Sometimes the advice that they're seeking is to do something stupid. Sometimes it may even be to do something illegal. That's why they have these conversations and get advice from trusted people. What this suggests is that by even having the conversation or saying something publicly or privately about it, one could be subjected to criminal liability. There are all sorts of actions that a president might take that might be aggressive, some of which are covered in the Mueller report with respect to appointing certain executive branch officials, firing certain executive branch officials, considering issuing certain pardons, engaging in executive orders, invoking the take care clause of the Constitution to actually involve oneself in an ongoing investigation if he thinks it's being unfairly conducted. All of those things can either be legitimate or illegitimate, depending on one's motives. And it would chill a president, I would think, to the bone to think that some prosecutor is going to be the person who is going to be making the determination about which action is legitimate, which is illegitimate, whether this was a mixed motive, a pure motive, or an improper motive. The mere fact that that inquiry could take place would have a chilling effect, which is why there is no clear statement that this obstruction of justice law should apply to the president, and which is why the independent counsel should have focused on facially illegal acts.
Well, you said it better than I could have said it. I just think that, I don't care if you're a Republican or a Democrat, I think if you're going to be in the White House in the future, that all of this is going to have and weigh on whoever that president may or may not be in the decisions that he makes about having frank and open conversations with his counsel, who he should be able to have very private thought process. What do you think about this? In confidence, knowing that the White House General Counsel isn't going to be subpoenaed to testify about very conversations that they had about what is going on in the White House. And so I thank you for your testimony here today, and I will yield the remainder of my time to Mr. Jordan.
Mr. Malcolm, just let me go back to where we were a few minutes ago. In the Mueller report, it says, our report does not conclude that the president committed a crime. It also does not exonerate him. I'm trying to figure out how that squares with Title 28 of the Code of Federal Regulations impacting special counsels, where we read before, the Attorney General shall provide a confidential report explaining the prosecution or declination decisions.
Well, I don't think that it does, in addition to the fact that I don't think that it is any proper standard for any prosecutor to decide whether or not somebody has been exonerated. That's not the role of a prosecutor. It's not even the role of a jury. If a jury comes back and acquits somebody, it just says that they weren't found to be guilty beyond a reasonable doubt, not that they were factually innocent.
And it specifically says, when you read the section of Title 28, it specifically says the prosecution or declination decision reached by the special counsel. It doesn't say you don't have to decide at all. It says you got to pick one, and yet in his report he says our report does not conclude either way.
I read it the same way you do.
Okay, now why was he able to reach a decision though on one and not the other?
That you would have to ask him. He obviously felt comfortable with the state of the evidence. My guess is that his team was conflicted as to what to do, but that's reading tea leaves, and I don't read tea leaves very well.
All right.
Not recommend obstruction of justice charges against the president. And it,
What brought me forward was the invitation in this instance, where I thought, yes, I could share with particularly a lot of the people who were on this committee were either not born or they were very young when Watergate occurred. And it's quite striking and startling to me that history is repeating itself.
Shit.
And with a vengeance. So that's why I've spoken
No, you
out.
mean a perversion of history.
comment on them if you don't mind. The special counsel Robert Mueller is a prosecutor.
Old vote and Democrats should work together. This was a wonderful place to start a career in government, working for this committee. I'm not so sure today. There's too much polarization. You sense it in the questioning sitting here and the shots that get taken at witnesses. So what brought me forward was the invitation in this instance, where I thought, yes, I could share with particularly a lot of the people who are on this committee were either not. Quite striking and startling to me that history is repeating itself, and with a vengeance. So that's why I've spoken out.
Thank you very much. I yield back, Mr. Jones.
The chair recognizes the gentlewoman from Arizona.
Thank you, Madam Chair. Mr. Malcolm, so let me again talk about some particular excerpts. And after reading the Mueller report, it was clear to me that Mueller knew that he may not have a clear case that could hold a report. And in fact, he said, the evidence we obtained about the president's actions and intent presents difficult issues that would need to be resolved if we were making a traditional prosecutorial judgment. Namely, A, the president has Article 2 authority, and the acts the president engaged in are all exercises of the constitutional powers given to a president. B, Second, there was no underlying crime. It would be almost impossible, I believe, to prove corrupt intent, which is required in the obstruction statutes. And Mueller himself said, unlike cases in which a subject engages in obstruction of justice to cover up a crime, the evidence we obtained did not establish that the president was involved in an underlying crime. He goes on to say, the absence of that evidence affects the analysis of the president's intent and requires consideration of other possible motives for his conduct. And then he further says, the term corruptly sets a demanding standard. Then C, Mueller report says many of the president's acts took place in public view. So with all those excerpts right from the Mueller report, in the words of Mueller himself, what do you think about my conclusion that he thought maybe this couldn't hold up in court, and that's why he didn't do the charges?
Well, I certainly agree that any prosecutor who would consider bringing an obstruction of justice charge would weigh heavily whether or not the person who was alleged to have attempted to obstruct justice had engaged in the underlying criminal activity under investigation. And in light of the fact that the president did not engage, or any of his campaign team engage in that activity, he had all sorts of legitimate reasons to be upset by this probe and what it was doing to his ability to govern. And so you can like the president's conduct or not like the president's conduct. I don't think anybody here likes what the president does all the time. That would probably be an understatement. But whether he had a legitimate beef that caused him to do what he did, goes to the issue of whether or not he had a corrupt intent.
Thank you, sir. My next question is for Ms. McQuaid. In a January 2nd Newsweek article, you said, I think this case is far worse than Watergate. You said, I think this case is far worse than Watergate because it didn't just involve a burglary to intercept communications of your rival. It included, allegedly and potentially, a conspiracy to collude with an adversary, Russia. Obviously, you were wrong that there was conspiracy or collusion with Russia. Do you admit to that?
I agree that Robert Mueller concluded that he could not establish the technical crime of conspiracy. However, I do think it was worse than Watergate. I think this president worked with Russia. The report says that the investigation identified numerous links between the Russian government and the Trump campaign. It also says that the investigation established that the Russian government perceived that it would benefit from a Trump presidency and worked to secure that outcome.
Because I only have 25 seconds left. Ms. Vance, on July 6, 2018, you tweeted, dangerous is the right word. The president is sowing hatred, fear, and distrust in hopes he can divide the country enough to survive when the truth comes out about his campaign's collusion with Russia. Well, the special counsel's team wasn't able to find collusion between the Trump campaign and Russia, but apparently you did. What is it that you knew that the special counsel didn't know or didn't conclude on after 22 months, 2,800 subpoenas, 500 bench warrants, 40 FBI officers, and multiple attorneys?
So Mueller in his report is careful to clarify that he's not making any decision about collusion. He's making a decision about whether or not he has evidence to indict the crime of conspiracy. A conspiracy is an agreement and an overt act in furtherance of that agreement, and Bob Mueller didn't find that there is evidence of that here. That is a far cry from saying that there was no evidence of collusion. There's abundant evidence of collusion in this record.
Prove it.
And, to me, it's clearly evident that each one of these Democrat witnesses that is before us today has had multiple previous statements publicly bashing the President of the United States, and it's really hard for me to take your testimony that it's not biased.
Raised in the witnesses, as we've discussed, that's an important tradition the American people want us to maintain. Let me ask a few questions, Mr. Dean. First, a housekeeping matter. When were you first contacted about testifying at this hearing?
I'm sorry, about this hearing?
Yes, sir.
Probably a couple of weeks ago. I was initially told it was planned for the 20th, and then later it had been moved to the 10th.
We're just curious. We only got exactly 7 days' notice, and we had suspected this had been in the works for a while. On November 7, 2018, when Attorney General Sessions resigned, you went on CNN and you said, quote, "This seems to be planned like a murder. It's almost impossible not to interpret this any other way than a fact to undercut Mueller," unquote. Of course, now we know that didn't happen. The special counsel was allowed to finish his investigation, and the Attorney General or Deputy Attorney General never declined any requests made by the special counsel. So based on that statement, would you now admit that maybe you overstated the effect of the AG's resignation?
Well, what I was looking at was the fact that Mr. Whitaker was stepping in as an acting Attorney General, which was highly unusual, and that's why I made the comment I did. I think that when Mr. Whitaker got in there, he found the institution is much different than that of a U.S. Attorney's view of it. There's a lot of spine inside the main Justice Department, and it was not something he could possibly carry out any assignments he might have thought he could handle. So no, I wouldn't change my comment.
Okay. You also said in that same interview you believe Special Counsel Mueller had filed sealed indictments against the president's children and others that you said, quote, were high in the pecking order at the White House. But there weren't any such
Did I say
indictments.
they had been filed, or that was a potential, I believe is what I said.
I think you said they had been filed, but I'll give you that. That didn't happen, though, did it? Would you admit you were wrong about that?
Well, my recollection being it was there was the potential of it. I'd have to look at the transcript of the broadcast you're talking about.
Mr. Malcolm,
You don't remember what you said on
your
CNN?
legal experience and your expertise on the matter before the committee have been very valuable to us. A couple questions for you. Many of the acts of alleged obstruction involve the president exercising his Article II authority that you've articulated very well today. Can you just explain the difficulty quickly in finding corrupt intent to obstruct justice when a president is carrying out those Article II powers?
Well, you have to be able to determine that it was done for an illegitimate purpose, that it was done to be purely self-serving and outside of the scope of the president's duties. And when a president is undertaking discretionary actions that are covered by Article II, which vests certain powers and duties in him, it is a very dangerous inquiry to go and look at and say, well, did he appoint this person because he's a crony? Did he appoint this person because he's going to do his bidding? Or did he appoint him on the merits? When he dismisses somebody, did he dismiss somebody because they were going to find some shenanigans that he was engaged in? Or did he dismiss him because he was incompetent? Or did he dismiss him for all sorts of other reasons? Anytime a president will be chilled at the thought that when he engages in these actions, a prosecutor, again, perhaps a politically motivated one, is going to be plumbing his mind to try to figure that stuff out. And, you know, it treads on separation of powers concerns that are quite real. Bribing somebody or illegally wiretapping somebody or threatening witnesses or suborning perjury, facially illegal acts. There is never a proper motive to do any of these things. But with respect to all of the things that I just talked about, and which are many of the things that Special Counsel Mueller looked at, to be done for all kinds of motives, both proper and improper.
Very good. One more question. If this committee were to go to court to enforce the subpoena for the full unredacted Mueller report, at this point in the process, how do you think you would assess the merits of that lawsuit?
Oh, they'd lose.
Well, at the moment, I believe that this committee would lose for the very simple reason that you are in the District of Columbia. The D.C. Circuit, in a case a couple of months ago, McKeever versus Barr, determined that there are no exceptions to 6E. Federal Rule of Criminal Procedure 6E governs the exceptions in favor of disclosing grand jury material, and disclosures to Congress are not covered by that. This committee and Congress can, of course, amend the law if it wants to, but at the moment, the governing law in this circuit, unless and until it is overturned, 6E material is governed by the exclusions there and nothing else.
Thank you very much. In spite of all that's been said here today and the countless interviews and the op-eds of our colleagues and all that, here's the one key fact we want everybody to remember. The White House and the Trump campaign provided unprecedented levels of cooperation with the Special Counsel's investigation. They produced over 1.4 million pages of documents to the Special Counsel. They allowed 20 White House officials to testify, including 8 people from the White House Counsel's office. And in spite of all that, the Attorney General and former Deputy AG Rosenstein found the evidence developed by the Special Counsel was, quote, not sufficient to establish that the President committed an obstruction of justice offense, unquote. That should have ended the inquiry. But it hasn't. For doing these political hearings, we're wasting the American people's time. This committee has one of the broadest and most important jurisdictions of any committee in Congress. There is critical work we need to be doing, and we're not because we're mired in this. I'm out of time.
And the emphasis on high places is important because as the president, of course, he has the pardon power, which is the ultimate safeguard for Michael Cohen if he is to remain loyal to President Trump.
And I yield back.
Too bad he's sitting in the fucking can, ain't he, bitch?
The gentleman from Texas, Mr. Ratcliffe. Chairman, I wish I could say I appreciate you holding this hearing, but I can't because I don't. With due respect to some of the witnesses, some of whom have a background similar to mine at the Department of Justice, this has been just another in the latest of panicked, short-notice hearings where, despite Democrats telling us it's a vitally important hearing, in order to prepare for it, Republicans received the testimonies of the 3 Democratic witnesses an hour before the hearing started.
Oh, shit.
Hearings featuring buckets of chicken and convicted felons, unfortunately, have become the norm for this once esteemed committee. So to any of my fellow Americans who are still tuned in, although I don't know why they would be, let me remind you how and why we're here today, why we're really here today. Hearings featuring buckets of chicken and convicted felons are being held by members of the Democratic Party that commissioned and paid for a dossier that falsely claimed that Donald Trump was part of a, quote, well-developed conspiracy, end quote, with Russia. That same dossier was used by a Democratic administration to justify an investigation into their own false conspiracy allegation. And now that the special counsel has conclusively and unequivocally found that there was no conspiracy between any American and the Russian government, much less a conspiracy that was well developed between Donald Trump and the Russians, well, those same Democrats who tried and failed to get rid of President Trump with a conspiracy that never existed, well, they are now undeterred. Now they want to justify their efforts to ultimately perhaps impeach Donald Trump by alleging that he obstructed their false conspiracy investigation. Now, even if we set aside whether it's even legally possible to obstruct an investigation that is not lawfully predicated, which this one may ultimately prove to be, and even if we set aside whether or not any president can obstruct justice by doing what the Constitution allows or authorizes a president to do, like fire any executive branch employee, even if we set all of that aside for now and focus instead on the fact that this obstruction of justice narrative against Donald Trump was started by the very same people who started the false conspiracy allegation. I'll remind my fellow Americans that it was Jim Comey who started the obstruction of justice theory in memos that he intentionally leaked, and some would submit unlawfully leaked, in order to start this special counsel.
He admitted it.
And it was Andy McCabe and Peter Strzok and Lisa Page and Jim Baker who opened this obstruction of justice case after discussing the ridiculous theory, false theory, that Vladimir Putin may have ordered Donald Trump to fire Jim Comey. So now today, to advance that obstruction of justice investigation into an investigation where there was no conspiracy, my Democratic colleagues have called 3 witnesses. 2 of those witnesses were part of the Obama Justice Department when it started the false conspiracy allegation.
Oh, shit.
To opine against the very same target of the false conspiracy investigation. And the 3rd witness that the Democrats called is Mr. Dean. Now, Mr. Dean, I have no problem with you having an opinion. You've paid your debt to society, and you've made your opinion clear. In the last 2 years, did you know you've sent 970 tweets about Donald Trump? All 970 tweets about Donald Trump are anti-Donald Trump. So you are entitled to that opinion about him. You don't have to like him. But because of disbarment, you are legally prohibited from having an opinion about obstruction of justice. Look, to my Democratic colleagues, unlike Bob Mueller, who needed to find a crime to indict and did not, you don't need one to impeach Donald Trump. You don't need one. It's the same reason why the chairman, within days of Donald Trump getting elected, talked about impeaching him. It's why some Democrats on this committee voted to impeach Donald Trump just a few months after he was into office. It's why some Democrats on this committee voted to impeach Donald Trump before a word of the Mueller report was ever written. Look, you're in control of the House, and at the top of the House is a Speaker of the House who has reversed the presumption of innocence in this country to a presumption of guilt, and said last week that she plans to see Donald Trump in prison. So, I don't know what your plans are. You all can do whatever you want. Let's stop wasting our time and just do it.
It's true that fact witnesses have been ordered by the White House not to appear before this committee, but we'll get them. Gentleman from Virginia, Mr. Klein.
Thank you, Mr. Chairman. It's my hope that we do have the witnesses in question, because this has really degenerated into a sad spectacle. The majority has a bunch of questions. They have neat charts that all have questions that are really meant for the Attorney General or Special Counsel Mueller or Mr. McGahn. But instead we have these witnesses here. I hope that the majority would enter into real negotiations with the White House instead of what happened, which was several weeks of demanding that the Attorney General release grand jury testimony against federal statutes and break the law in violation of code, and instead move off of these demands that we have staff, lawyers, ask questions of the Attorney General, which has not been done in any other case outside of an impeachment hearing, and actually negotiate with the Attorney General. And I bet we could have these questions before the actual fact witnesses instead of MSNBC stars and stars of miniseries. You know, and Mr. Dean, I'd say in '79 when you were played by Martin Sheen, that was great. In '95 you were played by David Hyde Pierce. That's a little bit of a step down there. And in '99's Dick, you were played by Jim Brewer from Saturday Night Live. I hope there's not another remake of that, because I don't know where you go after that. But I want to focus on some of the statements that have been made about Volume 1. You know, if we were really doing the work of the people here, we would be focused on Volume 1 and how to stop Russian interference in our election system. Instead, we're focused on, I guess, talking to some of the final people who really believe that there still is some kind of collusion. I'll ask Ms. Vance. Professor Vance, on November 30th, 2018, you tweeted, "At some point, all the times he said no collusion are going to come back to haunt this president." Do you still believe that there was collusion?
So it's important to note, as Mueller does.
That's a yes or no. I've got 2:45 left.
It's not a yes or no answer.
Okay, then let me go to your next tweet.
There's a difference between
I'm going to reclaim my
collusion
time.
and conspiracy.
Okay, do you believe there was conspiracy?
Mueller finds that he has insufficient evidence to charge a conspiracy, but he also notes that much evidence was kept from him, that people took the Fifth Amendment, people lied to him, people destroyed evidence on applications like WhatsApp.
Okay, so he didn't exonerate, but
He notes that if he had had the opportunity to get that evidence, he might have been able to view the situation differently.
As a former prosecutor, do you believe that it's the job of a prosecutor to exonerate the defendant, potential defendant?
In a typical case where I'm looking at indicting a bank robber, say, or a drug case, I would agree that it's not my job.
Okay. On July 6, 2018, you tweeted, "The president's sowing hatred, fear, and distrust in hopes he can divide the country enough to survive when the truth comes out about his campaign's collusion with Russia." Do you believe the truth has come out about the president's collusion with Russia and that there is none?
Again, I think that there's an enormous difference between collusion and conspiracy. There's evidence of a lot of contact, a lot of welcoming with open arms by this president, cooperation and help on the campaign from Russia.
You
So the
lying
American people should
bitch. She is lying through her fucking teeth, guys.
read volume 1 of the report and draw their own conclusions about what that gap is between collusion and Mueller not having sufficient evidence to charge a conspiracy.
On January 8th, you tweeted, "Video clips of people saying no collusion have not aged well. I would argue that these tweets have not aged well." And with that, I would yield to the gentleman from Ohio.
Thank the gentleman for yielding. Mr. Malcolm, I have the appointment of Special Counsel Mueller, the one-page document that makes it happen on May 17th, 17, signed by Rod Rosenstein. In there, he says the last point, item D, section 600.4 through 600.10 of Title 28 of the Code of Federal Regulations are applicable to the Special Counsel. And 600.8C says this: at the conclusion of the Special Counsel's work, he or she shall provide the Attorney General with a confidential report explaining the prosecution or declination decisions reached by the Special Counsel. As I read that, it seems to me that the Special Counsel was either supposed to prosecute or decline to prosecute. Not say, I can't decide. Not say I can't decide because there's a OLC opinion at the Department of Justice. He's supposed to pick one or the other. Do you read it that way?
Yes, I do.
And you said that in your testimony. I think your written, I don't know if you said that in your statement, but in your written testimony, you said it was the duty of the Special Counsel to provide the Attorney General with the confidential report explaining what I just read, the prosecution or declination decision reached by the Special Counsel. So you think Robert Mueller failed to do his duty in making a decision?
That is my opinion.
Yep.
Okay. That I yield back, Mr. Chairman.
Thank you, Mr. Chairman. Everybody knows what's going on here. For 2.5 years now, the American people were force-fed this monstrous lie that Donald Trump's a traitor who conspired with a hostile foreign government to steal the election. This lie was concocted through a phony dossier commissioned by the Clinton campaign. It was used by the highest officials in the FBI, our intelligence agencies, and our Justice Department first in a failed attempt to interfere with our 2016 presidential election, and then to undermine the constitutionally elected President of the United States. The first calls for Donald Trump's impeachment were heard within 1 week of the election. That was 2 months before he was even inaugurated as president. The day after the 2018 election, the chairman was overheard discussing his impeachment plans on an Acela train. Despite an outrageously biased team of partisan zealots who were assembled by Mr. Mueller, which initially included the now infamous Peter Strzok and Lisa Page, and some of the most abusive prosecutorial tactics employed, the $25 million, 22-month investigation found no evidence to support the collusion lie. So now we have a new lie, that the president obstructed justice in the investigation in which he was falsely accused of treason. The only evidence we're presented is that he was blowing off Trumpian steam behind closed doors in words that amounted to no action whatsoever. And they ignored the fact there was no underlying crime. His campaign and administration turned over every document requested of them, some 1.4 million pages. He waived executive privilege to allow his White House counsel to testify. And, by the way, he had the authority to do directly what he's accused of suggesting others do, and he did not. I have to tell you, if every politician told who tells his staff, "I'd like to strangle that guy," is ipso facto guilty of attempted murder, well, you might as well turn out the lights and close the doors in this building. Now, Mr. Malcolm, you're a former assistant U.S. attorney and deputy assistant attorney general. I'd like your professional opinion on several aspects of the Mueller report. The entire genesis of the Russia collusion hoax was the Steele dossier and how it was used by government officials to promote this false narrative, to influence our election, and to use it as the basis of warrants to spy on the Trump campaign. Yet the Mueller report largely ignores the very seminal acts that gave rise to these charges in the first place. Does that raise any red flags with you?
First of all, thank you for the question. I was feeling lonesome here. I look forward to reading the Department of Justice's Inspector General's report on that very issue, but there's scant mention of it in the Mueller report.
Does that trouble you?
You know, look, he did what he did. He had his focus. There are other things that he could have focused on that I wish he would have, but it seems that those matters are getting the attention that they deserve now.
Well, two revelations have already arisen involving the Mueller report. One concerns the report's recount of a conversation between John Dowd, the President's counsel, and Robert Keller on behalf of Michael Flynn. It omitted about half of Dowd's words to give the false impression of suborning a witness. The other thing we've learned recently is that references to Konstantin Kilimnik's interactions with Paul Manafort in the Mueller report identify him as having ties to Russian intelligence, but omit the fact that Kilimnik was, in fact, a U.S. intelligence asset. Do these material omissions raise any concerns with you?
Well, I've read both of those. With respect to the references to the Joint Defense Agreement, even when I read it at the time in the Mueller report, there's nothing wrong with the defense counsel for another person calling up, even someone who's cooperating with the government, and said, look, one, you can't breach what was said in the Joint Defense Agreement.
But omitting the exculpatory words.
I'm sorry?
Omitting the exculpatory words in the report, does that bother you?
Yes, that bothers me, and I thought it was an unfair characterization in the report, even when I read it at face value.
And the omission that Kilimnik was, in fact, a U.S. intelligence asset?
If that's true, then I would be bothered by its omission.
It was recently revealed that Trump campaign workers were lured overseas by U.S. intelligence agencies, specifically to evade U.S. laws on observation. Does this raise any concerns with you?
Yes, it would certainly raise concerns, and that's what I assume that matter is now going to be covered.
We're regaled with all of Trump's bombastic statements behind closed doors, telling his staff to do this and do that. But if the president had actually been serious, why couldn't he have simply picked up the phone and said, Mueller, you're fired?
Well, that's a very good point. So when you are going to look at the context in which statements are made, it also includes the individual involved. And let me be clear, I'm not here to defend the president's conduct, just the rule of law. You know, there are many things the president does that I wouldn't do, but just because somebody acts impulsively or in an uncivil manner does not mean that they commit a crime. He has surrounded himself with people who are used to his style, who sometimes realize that this is a president who publicly and privately acts impulsively and vents, and sometimes they ignore him. And in fact, there have been no repercussions to any of the people who ignored him. And you are correct, the president could have fired Rod Rosenstein, he could have rescinded the regulation that called for the, when Mueller could have been fired, he could have fired Mueller, he could have done any number of those things. It would have caused political problems for him, but he could have done them, and he didn't.
Gentlemen's time